Hi everyone, thank you for joining us for this webinar this morning on things that you missed when you took out that commercial lease. This is for people who are thinking about that or already have done that. So some top tips if you're not doing it yet, and maybe some rescue scenarios if you have. Lee's going to introduce himself in a minute. My name's Keris. I'm from the Growth Hub. The Growth Hub is an access point to free business support across Cornwall. We're in a bit of a transition phase at the moment. So we're having a bit of a pause while we go into a new funding model. So we're not actually kind of up and running at the moment. So we're having a bit of a pause. But we are still around, and the Growth Hub still has funding. It's just we're just having a bit of a pause at the moment while we reassess and look at our model going forward. But we're still happy. The website's still up and running. Still there. The team is still going to be developing the service going forward. But I'm not going to introduce myself too much because I've not really got not much to say about that. But just to say that I'll talk you through some of the admin side of the platform. It's all cameras off and muted. So if you want to put things in the Q&A, please feel free to do that. You can also tick the box and do that anonymously if you want. Lee will be sharing his contact details if you wanted to get in touch with him directly at the end as well. I probably just say for the Growth Hub, other dispute organisations are available. But thank you for Lee for doing this for this webinar for us. We're really interesting to hear that for myself as well. So I'll let Lee take over now and let him talk, and I'm going to go off camera, and we're going to get to questions at the end. So if there's any immediate questions, I'll try and answer them in the chat, but we're going to go through the Q&A at the end.
All right, thanks, Keris.
Are you all right to share your camera? I'll stay on screen just to let you know that it's working.
Okay, I think I'm sharing my camera. Shout if I'm not. Good morning, everyone. The name of this webinar is Things You Missed When You Took on That Commercial Lease. So who's this for? Well, as the title says, I've approached the job on the basis that some people sign up for leases not really getting the advice they need, not listening to that advice, finding they're in the middle of a legal relationship without really knowing what they're doing. So it's for them as a reminder or a first mention about the sort of things they ought to watch out for and what rights they've got. And I hope to be catching them before a problem arises. It's also for anyone who's thinking about taking on a lease but is worried about the legal side of things and hasn't taken any advice yet. Now, nobody will find all of this useful, sorry, but some people will find something they didn't know, and if that happens, then I'll be happy to have made a difference. This isn't a comprehensive deep dive into everything that might ever happen. Think of it as a greatest hits compilation, highlights I've organised and edited into a length that people can handle, so long as you appreciate that I've left out loads of other bits. So, why should you listen to me? I'm a litigation solicitor. That means I deal with disputes all the time, and I see them when they reach a point of catastrophe, normally which could have been prevented with earlier intervention. I clean up the car crash, and I can usually see where it started to go wrong. I was head of litigation at a regional firm where I stayed for 18 years, and in that role, I've become one of the most experienced property litigators in the Southwest. And from there, I could see that there were swathes of clients who had nowhere to go when they needed help. The market in Cornwall isn't built for small businesses, and in many respects, is still living on legacies of the past. And that's what Stutt Associates is about, to focus on disputes only and avoiding them, directing all of our resources, skill and experience on that with the aim of letting people directly access the right advice and assistance. I fight commercial property disputes every day. I've taken loads to court and I've avoided court with loads more, and that's better. Nobody wants to end up at court, and you probably can't afford it either. And most of the time, when all the information is available, the answer is also available, and court can usually be avoided. But sometimes the way things have been set up aren't best for tenants, and in that case, all you can do is see things as they are and make the best you can of the lease and the situation. So I want to talk about some of the things that might lead you into a dispute. And from there, we can see if you're at a particular risk, if you're in trouble, if there's an escape route available, if you've got the right knowledge, or whether you need to look at walking away. I'm going to show you what the standard clauses are that appear in virtually all leases, because some of them aren't obvious unless you know what you're looking for. And in particular, we're going to talk about security of tenure. That's the right to stay in premises, even if you haven't got a written lease or your lease is over. We're going to talk about dilapidations. That's the repair bill that landlords give to tenants at the end of a lease and how you might avoid that bill. We'll talk about offloading your lease, what to do if things change and you need to get out of Dodge fast. We'll talk personal guarantees and what they mean to you. We'll talk about how a landlord can take possession by forfeiture, and we'll finish with the balance between the landlord's need to carry out repairs and a tenant's right to not have their occupation interfered with. If anyone has any questions, I'm easy about whether you wait till the end or jump in earlier if you think you might forget or the moment might pass. Now, if there are any lawyers who snuck in, they'll have plenty of reason to say that I'm oversimplifying things. I know that's the point. There are other bits around the edges and outside of these greatest hits that make my simple explanations a bit Mickey Mouse if taken to pieces, and which might be important in a specific set of facts. So don't treat what I say as the answer to a really specific problem, just a grounding, a whistle-stop tour. My insurers require me to say that although I'm a lawyer and a reasonably good one, I'm not your lawyer, and you shouldn't take anything I say here as being the final word of advice on any specific situation you might face. There might be complications that go beyond the basic structures I talk today. But by all means, speak to me afterwards if there's anything you want to raise with me. But we'll start with the criminally misunderstood situation of a tenant's right to stay in property. Have you noticed that shops don't usually move, that they stay in the same place for 40 years, even though leases are rarely more than 15 years? Well, there's a reason for it. They get repeat leases when the current one ends. This is because of an ancient secret law that's been enforced for more than 70 years that people still don't know about. This should be taught in schools, and it should certainly be required reading for anyone in business. Businesses can have a 10-year lease, but they don't move on after 10 years. They stay for decades, even though they only moved in on a short lease. It's the Landlord and Tenant Act 1954, the 54 Act to you and me. It's what gives tenants security of tenure. It's changed a little, but fundamentally it set out the law in the 50s, and it's remained the same since. Security of tenure, the right to stay. It means tenants can't just be evicted even when their lease ends. Those rights are in section 24. And I'm going to try and show you section 24. There we go. The section comes in two parts. First, a tenancy to which this part of this act applies, and that's basically any that are run for a business, shall not come to an end unless terminated in accordance with provisions of this part of this act. And also, the tenant or the landlord under such a tenancy may apply to the court for an order for the grant of a new tenancy. So, two things can happen instead of them just leaving at the end. Two options open up. They can do nothing. That's the easiest thing, and it's perfectly safe to do. There's no rush or panic. They can carry on paying the rent periodically with the same terms of their lease carrying on. They're protected from eviction if they do. This could carry on forever in theory. Just keep going on the same lease until someone decides to make a move. The timescales aren't a problem for tenants. If they don't request a new lease, they stay anyway on the same terms as the current one indefinitely. And then they can serve a notice requesting a new tenancy later on, no rush. Or if they want, they can ask for a new lease. And then they can negotiate the terms of that new lease to be whatever they want. And if they can't agree, the court will give them one of up to 15 years. That's if they want the security of a fixed term. As you see there are notices that need to be carefully served when this needs to happen in sections 25 and 26, and it's important to get them right. These are the sort of things often best left to solicitors. So, tenants have the right to a new tenancy when the current one finishes. What tenancy are they entitled to? Probably one identical to the current tenancy, just updated if the language or the law has changed, and maybe changed to the rent and to the length. And that's how tenants stay where they are. Shops don't move, and you can rely on high streets being pretty constant. Now, landlords may say the rent should go up, or the tenancy should be a short one, and those things can be negotiated, but they can't force in new terms. Anything new would have to be agreed. So if the current lease puts the repairs on the landlord, that stays in a new lease, unless for some reason you negotiate something different. If it gets to the court, though, then the court would order one on the same terms as the current one. Security of tenure carries on until the tenancy is finally ended. That's where the bit of section 24 that says, unless terminated in accordance with the provisions of this part of this act comes in. So let's talk about what that means. Terminating in accordance with this part. It means that although the tenant is entitled to request a new tenancy, landlords are able to object to that request, but only on very limited grounds. They can serve a notice saying they don't want you to have a new one, but they have to have specific reasons. They can't say they want to sell or they want to move someone else in. The most common are first, that they want to occupy the space themselves. That's the most popular. Or secondly, that they want to do serious work to the premises that can't be done with the tenant in. If they say either of those things, then you're in a legal argument and you're at risk. And that's probably a time to take some specific advice, because then you'll need to decide whether to accept what they say or challenge it. But they can't make reasons up. They have to be real intentions and they have to be possible. They have to be able to realistically do them. And there are safeguards to protect tenants from landlords abusing them. Compensation for losses caused by the deceit. I'll give you a case example. McDonald's had a restaurant on the south bank of the Thames, County Hall, next to the London Aquarium. Made a lot of money right in the centre of London where the tourists go. They've been there for years, since 1997, and they had security of tenure. In 2016, they requested a new tenancy. The landlord said it would oppose that. The reason given is this: that on the termination of the current tenancy, we intend to occupy the holding for the purpose, or partly for the purpose, of a business to be carried on by us therein. We intend to carry on business as Zen Bento Box or similar, which business will be carried on by our wholly owned subsidiary, County Hall Cuisine Limited. That was an available ground of opposition that the landlord could use to end McDonald's security of tenure. McDonald's put up a fight. They wanted the landlord to prove its intention to occupy a Zen Bento Box. They had a trial. The landlord produced evidence, witness statements, board minutes, evidence of other companies that the landlord had used to run restaurants in County Hall before, a business plan, quotation and programme for works. An executive team was set up and the landlord was experienced in food outlets. Their barrister clinched it with the line, well, what else is he going to do with this valuable unit? Leave it empty? The judge in that trial accepted the landlord's intention was real and did what it felt it had to do, which is make a termination order, ending McDonald's security of tenure. McDonald's moved out. But the landlord didn't open that Zen Bento Box. Immediately after that judgment, he started excitedly emailing agents with other new ideas for the premises, none of them a Zen Bento. In the end, a much scaled back effort at a Japanese fast food outlet was opened to pay lip service to the stated intention. And the evidence given, it turns out, was created just to get them out. And all of this came out in evidence in a second claim in which McDonald's proved that the intention was never a real one, opening the door to a huge claim for losses for the wrongful termination of its lease. And that's how seriously these things are looked at. A landlord can't invent an intention, but this kind of thing happens all the time. Landlords looking to find a reason to take possession, and it's important to look at whether it's a real intention. It's not enough to say that the landlord wants to sell the premises or move someone else in. 54 Act protection is the norm. You probably want it. It's what lets you stay in occupation even after the lease has ended. It's imposed on every lease of more than 6 months by statute, unless the landlord and tenant agree to opt out. And they should know if they've done that, because they'll have formalised that agreement with some prescribed signed forms. If you've done that, then you're out and looking for new premises after your lease ends. Why does it matter? Some people are better off with an excluded lease, but not many. It's okay if you know you'll only be there for a fixed time and then plan to move. For anyone else, it's dangerous, because at the end of the lease, you'll have no right to stay. So if you want to stay, you'll be held hostage to the landlord's demand. If you don't like them, you'll have to go somewhere else. And if they offer you a new lease, then they'll insist that's excluded too, knocking the problem down the road. So if you don't have 54 Act protection, 1, you have no right to stay when the lease ends. 2, if you want to stay, you're held hostage to the landlord's demands. And 3, if your business was successful, then the landlord can take the benefit of that success and use it against you, because your success is what made the property more valuable and desirable. So they'll be able to demand a higher rent, all because of your work and goodwill. Know what your status is. And if you have a protected tenancy, have a plan for when the lease term ends, even if that plan is to hang on indefinitely. 54 Act protection, you probably want to have it. And if you have it, know how to use it to your advantage before your landlord does. Does anyone want to raise anything with me about that part? Happy to leave it to the end if you prefer.
There's one question, we can probably leave that till the end, I think.
Yeah?
Yeah.
Okay. Well, in that case, one of the side effects of staying in occupation is that if you stay there, you'll never have to deal with end of lease dilapidations. Dilapidations is the repair bill when you leave, because in theory, when you moved in, the premises were perfect. And so when you leave, they should be too, so that it's handed back the same. Your lease will almost certainly have a covenant on your part to keep the premises in good and substantial repair. I'm going to try and find an example. Is it? Nope.
An agreement just flashed up there, and then it
Yeah,
went off.
that's the wrong one.
Ah, right, okay.
That's the one. There's the right one. Okay, if it doesn't have a clause like that, then it's the landlord's job to do the repairs, and that probably means there'll be a right for them to charge for those repairs as well, and that may well be worse. So the repairing covenant means fixing the things that are damaged. The requirement usually is only to put the premises in the condition they were in when you moved in. You'll see that here on this example at 4.5. Occasionally, there might be a clause that says put and keep in repair. This is really bad. It means you have to make them better than they were. But let's assume we're talking about a regular covenant to keep premises in repair. And this means everything. It can be really minor things: peeling paint, a patch of damp, nail holes. If when you took it on, it was fitted out in a particular way, then you technically have to put it back like that. This is why it's important to have a good schedule of condition at the start, with photos all approved and agreed by everyone, and to do a full walkthrough before signing on and moving in. Bring any defects to the landlord's attention at the start, like when you rent a car. Point out every scratch, however tiny, so that you can't be blamed for it. Don't be shy. If you don't point out a tiny bit of black mold at the start, then at the end, when it's a massive damp patch, it'll be your fault. If there isn't one, that's not ideal, but it's more of a problem for the landlord, because it's the landlord that has to show how it's fallen into disrepair. And they can't easily do that without before and after photos and a schedule of condition. But if there is one and it's agreed, that's the standard you'll be held to when you leave. Now, depending on the wording of the clause, this can lead to huge problems. And full repairing leases are also common. This puts the onus on the tenant for everything that needs fixing for the whole of the lease, and to give it back in a fully repaired condition at the end. I've seen premises where tenants moved into a shop with a totally defective roof, structurally unsound, repairs required by the local authority for the benefit of everyone, especially customers. But the lease put that liability on the tenant. The landlord must have known about it, but the tenant didn't, and didn't think to inspect the roof space before signing the lease. So from a practical point of view, keeping a property in good order is obviously best practice. From a legal point of view, it is as well, because you're only going to have to fix it at the end when you're about to move out. So you might as well do it while you're still there and at least get some benefit from your repairs. How does this work in practice? Well, there's a protocol for this, with the intention of dilapidation disputes never going to court. But the protocol itself is pretty scary. And how it works is this. A few months before you're expected to move out, your landlord will send a surveyor around to inspect. He'll quietly look at everything, giving nothing away with a clipboard or an iPad. And this is supposed to be helpful. It's supposed to put your notice of what's expected before you moved out. This surveyor is not your friend. He's being paid by your landlord to protect their investment. He's a detective. The next time you hear from him, it will be with 3 unpleasant documents. First, a schedule of condition. This will look like a spreadsheet and will refer to a thing said to need repairing, the term of the lease that it relates to, and a figure to represent the maximum humanly possible cost of fixing it. You'll be surprised how much it costs a landlord to paint over nail holes. These are things that a landlord says shouldn't have been allowed to fall into disrepair. Second, supporting photos taken from the worst possible angle, unlike the photos taken at the start. And third, a quantified demand, where you're asked to pay the total of all those maximum estimates. When you get these things, you have 3 months to respond. If you don't, your landlord is free to sue for the total and say you chose not to participate. What you should do instead is work out what things can be fixed and fix them. Get professionals to help and have someone check through the schedule and prepare a counter schedule, because there may be things in there which shouldn't be. Some things may be landlord jobs slipped in there, some may not be in actual disrepair, and some may be overpriced. You need to have proposals to go back with and to answer all the allegations. Actually, it's worse than that, because if you look at clause 4.4 here, the lease will almost certainly make the tenant pay the cost of the scheduled dilapidations. So the surveyor's costs, potentially any legal costs too, involved in drawing up the schedule. And that may not be cheap, and is all the more reason to make sure there's very little for the landlord to complain about. They'll still complain, they always do. There's a potential trick available that the landlord won't tell you about as well. They can't claim more than the amount of the value the building has actually lost. So if the building is still worth the same, even though it's in disrepair, or the landlord intends to demolish it, there's no viable dilapidations claim. Now, that's beyond what we're talking about today, but be aware that there are tricks available. If you get your own surveyor appointed, they ought to be able to sort all of this out. I'll give you a case on this too. Post office versus Aquarius is a good example of answering a dilapidations claim. In that case, post office leased a building where, due to a rise in the water table, the basement became ankle deep in water. The landlord tried to put the obligation to fix it on the post office. The post office successfully argued this wasn't disrepair. it hadn't fallen into disrepair, and it wasn't in breach of the covenant. The damage was caused because the building was defective. It had no damp proofing. The post office couldn't put it into its original condition to fix the problem. The problem was its original condition, not a failure on the post office's part. So that's a quick overview of dilapidations. Obviously, keep the premises in good nick and give the landlord as little to shout about as you can before they try to charge you above market rate for fixing every little thing, plus the cost of telling you about their charges. Would anyone like to raise anything about dilapidations?
No, still just got that one question.
Okay. Well, in that case,
people need to think hard about the question. I think they're too busy listening to type questions.
are they too? Happy with that. I'll go on and talk about break clauses then. Because sometimes you have to get out. Circumstances change. Your life takes a turn. Business wasn't what you expected. The problem is that for the whole term of the lease, you're liable for all the costs of the lease. So that's rent, service charges, things that go with the premises too, like utilities and rent rates. You can't just get out. You have three options. Surrender. You can agree with the landlord to be released from the lease and bring it to an end early, but it needs the landlord's agreement. And unless they have someone lined up, they're going to say no. Assignment. You might be able to sell the remainder of the lease to someone else to carry on the business. But if you can't do either of those things, you're stuck in the lease, unless you have a break clause. And I've got an example. If I can get the right one. Is it that one? No. Is it? Might be that one. No, that's the forfeiture one again. Break clause. A break clause is an escape button. It allows a tenant out early so that liabilities stop. They're often negotiated for a tenant's benefit. Landlords don't really get break clauses because they can only be exercised in a way consistent with the tenant's security of tenure. But break clauses have to be exercised on particular dates, and those dates are always strict. They get drafted in at particular intervals. So a 10-year lease might have a break clause at year 5. They tend to be drafted to say that to exercise the break, written notice must be given at least 6 months before the date the lease allows you to break. If it says that, then 5 months and 30 days won't be good enough. It's got to be exactly what it says in the clause. There are standard conditions for break clauses. They will always make it a condition that rent is paid up in full, and often that there are no other breaches. This one here doesn't refer to other breaches. I'm not sure if I'm sharing it or not.
No, still looking.
Okay. All right, I've got a circle spinning for that one. It might come up in a minute. There's one there which may appear. This one here anyway, the one I'm trying to show you doesn't have one of those, but be aware that yours might. Often though, they're poorly drafted. So we've seen leases that don't make it clear whether the requirement for no arrears is intended to mean when the notice is served or when it expires. So whether it's at the point 6 months notice is given or whether it's at the date of the break at the end of those 6 months. And landlords who don't want to lose a source of income will take any point they can to challenge validity. They'll do so on the date, the words in the notice if they're not clear, a penny of arrears, often dilapidations if they have any cause to say the condition of the premises is ever so slightly worse than it was when the tenant moved in. That last one is particularly difficult because the landlord only gets to check after you've gone. So the scenario is you serve 6 months notice, shut up shop, spend a week doing decorations, moved out, and then your landlord says you didn't fix the paintwork, so your break isn't accepted. This is a problem, and exercising a break clause can be a matter of acute contract interpretation. So you might benefit from having a lawyer look at that at the time. As an example, in the case of Avocet, there was a break clause. It said that any break was only valid if there was no arrears of rent on the break date. On the break date, arrears had all been paid up, but the lease required interest to be paid on previous late payments. Now, they'd never paid interest before, and the landlord never asked for it. And they didn't pay the interest now, some £130. But under the lease, that £130 was technically rent, so some rent was unpaid. That meant the condition for the break hadn't been satisfied. So the break wasn't valid, and the tenant was stuck with the lease for several more years. Assigning the lease is another option, but any assignment will need to be approved by the landlord. They need to know whoever's in occupation of the premises is good for the money. And they probably also did that when you moved in, which is going to lead me nicely into personal guarantees. But before I do, are there any other questions?
No, we're still just on that.
No. All clear. Good. Excuse me. Okay, so personal guarantees. Lots of the time, people run businesses as limited companies. The whole point of that is that the liability is limited. If the business fails, then at least your personal bank account is safe. Personal guarantees are tools for landlords to bypass that protection. Personal guarantees, or PGs. Now, do I have any PG tips for you? Not really. No, I don't. I don't even have a typhoon. They're horrible and very hard, possibly impossible to escape from. They mean that you personally as a director have to pay the rent if the company can't. If the business hits a rough patch, then the landlord doesn't just sue the company, they come after you personally. If you enter into a lease as a small limited company, then the landlord is going to insist on some security because otherwise your financial risk becomes theirs. Unless your company has assets or a track record, they might not want to take a risk on you. This means they'll invite a company director to be prepared to personally step in to fulfill the tenant's duties if the tenant fails to do them. That puts you personally in the firing line for rent and repair costs, including dilapidations. Of course, if you enter into the lease as a sole trader rather than a limited company, then personal guarantees aren't necessary because you're on the hook anyway. Personal guarantees are always tightly drafted and really hard to get out of. I'll give you an example. In a case called Hui, a director signed a personal guarantee for a property lease. The business failed. Landlord came for the money under the personal guarantee. Director's argument: he was too drunk to understand what he was signing. The landlord's agent plied him with drinks. Even that was not enough to get him off the hook. Regretting a decision you made in the pub is not enough to get you off of a personal guarantee. And I mentioned earlier that one of the other ways to escape a personal guarantee might be an assignment, selling or even giving it away so that it's someone else's joy or problem. And let's see how that works in practice. You find some mug to take it on, they're happy with it, you shake hands, but there'll be a term in the lease that says you can't assign or sublet without the landlord's consent. That's standard. So you ask the landlord to consent, because they need to do a license to assign, and then they aren't allowed to unreasonably withhold consent. But they can make consent conditional to protect their property. And at the moment, your business is liable for the rent, and you've personally underwritten it with a guarantee. They don't want to lose that, so this is what they do. They make you guarantor for the incoming tenant. If that new tenant doesn't pay the rent, you still have to. And this is called an authorized guarantee agreement, or AGA. And AGA clauses are really common in leases. I'm going to try and show one now, buried in a lease. If I can even find the right one. That's E. There it is, camouflaged like a tiger, buried in the middle of that section. I've colored it red so that you can see it. And you can see where it fits in the lease. There's a section that says first, you can't assign the lease in general. And then there's one that says you can if the landlord consents. And then there's one that says if the landlord consents, they can put conditions on that consent, which include an authorized guarantee agreement. Buried in the small print, but there it is, definitely there. The effect of those is that even though you've got out of the lease and have no control over the incoming tenant, you're still guaranteeing their performance. If they fail, you're still on the hook. This is harsh. It's for a sensible reason, because otherwise you could get out of a difficult lease by assigning it to a dormant company that you just set up. But it can catch you out if you're looking to assign. And landlords will absolutely enforce them if there are arrears. They'd be mad not to. They've got their own interest to look out for. And it can work out very bad. If the new tenant just disappears, you're now liable for the rent and not even able to trade. If the landlord serves a notice of rent increase on them and they don't answer, your liability just increased. I've seen it where both happen. At least that allowed the landlord to propose a new rent, which would be effective if the tenant didn't object. The new tenant leaves completely. The landlord serves notice proposing to double the rent. Because the new tenant has left, that increase applies. And now the original tenant under the AGA is liable for that. So if you're going to assign a lease, it had better be to someone you trust. The good news is that an AGA like this only lasts for one assignment. If the new tenant assigns it on again, then you're released from liability. But that's outside of your control. So here's my PG tip. It's best to avoid them if you can. Would anyone like to raise anything about personal guarantees before I start talking about the exciting world of forfeiture?
We have got a couple more questions now. Did you want to do those now, or
Yeah, chuck them in.
plow on? Okay, so we'll do all three now. Oh, hang on, let me come back on camera. There we go. So somebody who's currently in court with an ex-landlord, they served a section 146 and gave 5 days to correct 3 breaches, which were not very serious. They moved out of the premises because of the enormous pressure threatening us to forfeit. The landlord still did after 60 days. Can you touch the forfeiture process and how it's supposed to be done? Have we covered that already? Because
that's the very next thing on the agenda. We'll come back to that after my next section.
Excellent.
If that's okay. Was there another question?
Perfect. So we've been asked. Somebody's been asked to move from a building yard where they were previously in the building that they surrendered during COVID, but they concreted an area for our use, but we never signed a formal lease through a paid monthly rent. The freeholder has changed and they want us out. We don't have a suitable alternative site. What's their situation?
That's quite a complicated series of facts. I might need to talk to them specifically about that afterwards. I think it sounds like there's a suggestion that there might be an unlawful eviction or a derogation from grant, but we can come on to that. If they'd like to make contact afterwards, that might be better for that one.
Perfect. Okay. I would imagine that a lot of these are going to be quite specific. So the last one here at this stage is they signed a lease for a beauty salon as part of a partnership. We used a rent share model to help with client flow. The landlord is saying this is classed as subletting and they need written permission. The landlord herself, while approaching other beauticians to come and work for us. So is she contradicting her lease?
Doesn't sound right to me. That sounds like there's some confusion going on in there. Again, it's a pretty specific example. So I think I'd like to know some more details about exactly what's happened, and then we can perhaps talk to whoever's asked that question about what their circumstances.
So a couple of those were anonymous. One of them is has got a name on it that I'm not going to read out for the because this is recorded. So if you wanted to reach out and for the one about the concreted area, I could potentially pass her email on if that's okay.
Yeah, do please drop the details over to me and I'll deal with them any way I can.
Okay.
Okay. Is it time for forfeiture?
It must be.
Okay. So forfeiture, security of tenure is a tenant's shield, but forfeiture is the landlord's sword. It's how a landlord ends the lease early. And something I can guarantee is there'll be a term in any lease that has forfeiture. And I'm going to find the example. It's not that one. Is it that one? There it is, first time. So again, it's missing the neon lights, the red flag you might expect, but it's definitely there. And it's described here as the landlord's right to end this lease, but that is a forfeiture clause. Forfeiture is how a landlord takes possession of the premises back without having to wait for it to come to its lawful end if the tenant does something seriously bad and doesn't fix it. So it happens when you're in breach. The most common breach is rent arrears. If you look at any commercial lease, there'll be a section titled something like landlord's right of re-entry, and it will say the landlord can re-enter if the rent is usually 14 or 21 days late. And you can see there it is here on 6.1.2a. If you get to that stage, you're in imminent danger, because at that point, the landlord can literally re-enter, and re-enter in this case means take back possession. It instantly becomes theirs again, and your rights as a tenant are all over, as long as they do it correctly. And you won't get any advance warning. That's not how it works. The first you'll find out about it is when you go to work and your key doesn't fit anymore. That's because the landlord has turned up overnight with a locksmith and changed the locks. They'll also tape a notice to the door saying they peaceably re-entered. They've taken back possession because of rent arrears. The lease has ended, as long as they've complied properly with what the lease says about re-entry. And this is really bad for business. Customers can't come in, so you lose trade, you lose money, you lose reputation. People talk and assume you're insolvent. Staff can't come in, and they lose trust as well. It's embarrassing. As long as the landlord does it right. If they do it wrong, then it's an unlawful eviction. The step by a landlord to forfeit has to be decisive, because the act of forfeiting is a choice, and it has to be a clearly exercised choice. It's like when a member of staff is caught stealing. You get two choices: sack them on the spot for gross misconduct, or let them off with a warning. You can't do a bit of both. The same with the forfeiture situation. If the trigger date arises, the landlord has to either end the lease or not. What they can't do is ring you up or write to you and say your rent's late or do anything else that you might interpret as letting you off and letting you stay. Normally that means demanding rent, but it might also be turning up to do repairs or anything else that's a landlord's job under the lease. Anything like that is only able to be explained by the landlord acting like the lease is continuing, not treating it as at an end. Anything that might be interpreted as something other than I end this lease now. Just as you can't say to your stealing staff member, you'll deal with them next week, you can't then decide to sack them next week after they've finished a few more shifts. And that's why they have to do it by surprise. So if you get in this sort of situation, if your landlord makes any contact about arrears, document it and keep it because it might save you. If they say nothing, then worry. They might have been advised to say nothing and just take possession. There are other reasons to forfeit besides arrears. In any breach of covenant situation, the landlord can serve notice requiring you to remedy a breach and threaten forfeiture proceedings if you don't. And Keris, you mentioned someone who's got that sort of issue. This is what I'm touching on now. Frankly, if you get into that position, take advice because it's going to get complicated. That said, look, landlords who seek forfeiture for anything other than rent usually have an ulterior motive. They want the place back and are looking for an excuse, or they're put in a corner because whatever the breach has caused them some other bother. They don't usually choose the forfeiture route because it means they have an empty unit unless they have someone lined up. And if they have an empty unit, they're liable for rates and other expenses, and their unit looks undesirable if it's empty, making it even harder to fill. So it's better for them commercially to have a tenant with a poor payment record than to have an empty unit. But don't take that chance. And just acknowledge it is a reality that might be useful to remember if things take a turn for the worse. In any of these cases, forfeiture ends the lease is dead right there, but it's still possible to bring it back to life. You can ask the court for relief from forfeiture, and that's an undo, making it as if it never happened. I'll give you a fun example. Central Estates and Woolgart. In this case, you got a tenant who had a criminal conviction for running an illegal brothel. He definitely did it. The criminal court said so. And that would be a breach under the lease because the lease prohibited immoral use. Now, once they're on notice of this, the landlord has to stop acting like a landlord, has to stop requesting and taking rent. Because if it does that, then it's not acting decisively and it's saying effectively, I know you're in breach, but I'm going to take your rent anyway, so you can take that as me deciding I'm okay with you staying. The landlord's staff are instructed not to take any rent. However, there was an automated system that was overlooked. It sent out a routine demand after the landlord knew about the breach, and the tenant paid it. By demanding and accepting rent, the landlord would waive the right to forfeit. They acted through automated systems like the lease was still alive, and the court had to agree with that. So they couldn't go ahead with the forfeiture, even though there was a criminal breach. Best not let it get to that stage, hey? Does anyone have any questions about forfeiture? Keris, do you want to come back to that one? Can I hear it again? Is it something I can deal with now, or is it too specific?
Let's have a read. So currently in court with let me turn the video back on. Currently in court with an ex-landlord.
Yeah.
They served a section 146, which gave 5 days to correct 3 breaches, which they say are not particularly serious. They moved out from the premises because of the enormous pressure threatening us to forfeit the premises, which the landlord still did after 60 days. Can you touch on the forfeiture process and how it's supposed to be done?
Yeah, okay. So can I touch upon the process based on what's happened in that case? So what you're dealing with is a breach that isn't rent arrears, whatever it might be, something not serious. What needs to be done there is a section 146 notice needs to be served on the tenant, which will require them to make good whatever has gone wrong, whatever the breach is, within a reasonable period of time. 5 days is a really short period of time for anything, really. So it depends on what the significance of this breach is, but it's difficult to see how much could be done in 5 days, and this is really very simple and can be fixed. If, however, we've got a person who's moved out after being served a section 146 notice, I don't know there's much that can be done about that other than applying for relief within 6 months of the act of forfeiture, which is taking place now, I think you said. So if we're now in a place where the lease has been forfeited, then your person who's making the inquiry now needs to see whether they've got any right to relief and if they want to pursue that. Yeah, any right to relief, or paying the landlord any any sums outstanding to them, including in relation to the notice, fixing anything that's wrong, probably going to the court if the landlord doesn't agree to allow them back in. I hope that's clear as mud.
So that was helpful. That was it. The other questions, we've got no more new questions.
Okay, well then I'll go to the final thing that I want to talk about, something which is supposed to be less contentious, where landlords and tenants ought to be able to work constructively together, but guess what? Quiet enjoyment and landlord works. We talked about tenant repair works, but some of the biggest conflicts can come from landlords repairing obligations, because those are often major and can impact on the use of the premises. Scaffolding's needed, the signs are obscured, place looks like a building site because it is one. And then you get a tug of war between the landlord's need to do repairs and the tenant's right to have quiet enjoyment, the right to use the property they're paying to occupy. And this comes down to two things. First, what the lease says. The lease will probably give a landlord the right to re-enter, to carry out works that are their responsibility, but they have to have a clause that does that. They don't have the right to enter to repair things. You find my example. There you are. The second thing is the elephant in the room. It's common sense. If the landlord is able to enter to carry out works, then someone has to take a view about whether they've gone too far with them. Could the work have been done in a way that caused less disturbance? Are they working on your restaurant premises during peak hours when they don't need to? Is there excessive noise and vibration? If so, they've gone too far. In an extreme case, you lose all sense of being the owner of the premises altogether. And then you might be looking at damages for derogation from grant, i.e. you haven't got the thing you paid for, or alternative premises. But that's really extreme, and the point of your premises is its location. So an alternative premises is probably no good. The reality is that disputes of this nature shouldn't need to go anywhere near a court, because if the works are needed, then a landlord and tenant should sensibly be able to agree a structure that allows them to be done efficiently and at minimum disruption, which has to be in everyone's interest. Sometimes, though, that means involving someone who can de-escalate it, rather than advocate your strongest case. So by all means, lawyer up if you want, but a Rottweiler isn't necessarily the best approach if you're looking to reach a commercial agreement. You either need a lawyer who can approach things sensibly and not make things worse with shouty threats, or you need someone to facilitate discussions, a mediator. Let me give you an example. Timothy Taylor's gallery owner, and their gallery is in Mayfair House. It's a high-class gallery, paintings worth tens of thousands. The landlord of Mayfair House wanted to rebuild the upper floors above the gallery. And you can't do that without scaffolding, but the scaffolding obscured the gallery completely. And the works they did caused enormous noise, so loud the gallery staff couldn't talk about the paintings, much less sell them. The landlord went in hard on this and claimed to have the right to do the works, that the tenant knew all about them, and that the rent of £500,000 a year was still payable, even though it was impossible to run a gallery. The tenant said there were other ways this scaffolding could have been done, and that the landlord didn't use noise monitoring equipment. And the court agreed with that and ordered damages that were effectively a 20% rent reduction for the whole period of the works. Now, in that case, and in really any case, none of this should be necessary. It ought to be able to be dealt with by commerciality and common sense. But perversely, it's often the involvement of lawyers that makes things worse, because a lawyer ends up putting their best, strongest case rather than mediating to a sensible middle ground. If a landlord insists on doing something that's obviously detrimental to a tenant's occupation and it didn't really need to, then it's at risk of a claim. And a tenant likewise has to appreciate that works need to be done and work with the landlord to do them. But the secret is for the tenant to be actively cooperative. Don't just say you can't do that. Say, have you considered putting the scaffolding up in a different way? Can you not do heavy drilling at a busy lunchtime? Can you help with signs to show you're still open? Propose a sensible rent reduction if you want. Not all of it, you'll never get that. Then the landlord would either agree and you've reached an agreement and no dispute, or at the very worst, they look entirely unreasonable. And at that point, you may not have any option but to instruct lawyers. And in that case, it makes sense to do it sooner rather than later, particularly if you're accruing losses, because the time will come when you can't afford not to. Now, I've spoken about a lot of things, so if anyone has any questions about this or anything else that I've raised that they're happy to raise publicly, now would be an excellent time to do that.
Okay, so I think the first guy who was talking about the Section 146 notice and the forfeiture process, They're saying they don't want to go back to the property, but they feel it was an eviction rather than the kind of proper process that was followed. So would they just sort of have to take that on the chin, or?
They might do. I mean, potentially if you've got a forfeiture carried out wrongly, it's non-lawful eviction. So there may be a possibility of claiming for damages. It's difficult to do that if they don't intend to go back in, because you're never going to be able to show you would have made any money if you'd stayed there. I think it's probably going to be fact sensitive. So again, I'm very happy to talk to them privately if they want to see if there's anything.
I suppose it's avoiding that situation in the future, isn't it? It's what they should have done at the time. Would it have been raising it when they gave them the 5 days to fix breaches?
Yeah, maybe.
They should have queried it at that point.
We are, as they say. So there's no point in crying over spilt milk if there's nothing that can be done about it now. But yeah, it's right. There are things that could be done when the iron's hot. You know, when you can deal with things as they're actually happening rather than coming back afterwards. It's sometimes easier to prevent something from wrongly happening at that time and try and make it better afterwards.
Okay, so we've got another question here. This is somebody who's a charity. The building that they rented was damaged in the storms earlier this year. The roof partially blew off. The landlord has accepted responsibility to repair the roof and make good the water damage, but the building is old and not in the best condition, and making good of the water damage involved was them just painting over the stains. So the lease is due to expire in 2.5 years, and the landlord has put the building on the market. Should we be worried that the basic repairs and decoration might fall to us, even though it was their work originally?
Well, it literally depends on what the lease says, and unless there's any requirement for this person as the charity tenant to carry out the works under the lease, then no. So
it would just be a case of them, if he's sort of already put the building on the market, it would just be a question of going into dispute with them about the outstanding repairs.
Yeah, exactly. That whatever the lease says about who has to do things and to what standard is where you'll start with that, and that's going to be informed by whether there are any building regulations or listed building consents or anything that may need it to be brought up to a particular standard. All of those things come into play on it. It depends on the lease. It depends very much on the fact. I'm more than happy to talk to this person afterwards if they want to.
So there's no more questions on there. We had a few that were sent ahead of time, which we might have answered because these were sent people who couldn't attend on the day. So how often do security of tenure actually go to court and need to be decided through court? Is that something that happens a lot? Or?
No, they're really rare, really. And it's often they need to be started in court because there are time limits that need to be complied with. So markers need to be put in so that limitation issues aren't missed. But it's very rare that they end up having to be decided, particularly where the only things that are in dispute are rent and the term of the lease. If you've got an issue about whether a tenant's been in breach or whether a landlord genuinely intends to occupy, those are the ones which do tend to go to court. Those are the ones where I think, in fairness, you probably want to have some representation.
Okay, and just a quick one about break clauses. Can landlords have break clauses?
Yeah, I touched very briefly on that. Landlords can have break clauses. The difficulty that they've got with them is how that plays along with the right of a tenant not to be evicted, because if a landlord exercises a break clause, it means terminating the tenant's right to stay. So the two have to be weighed together. And the difficulty for a landlord in that case is that to exercise a break clause, they've then got to serve notice as they would if they were terminating a lease at the very end of it. So they've got to show a reason to object to a new lease being granted. And then for that reason, they rarely come into play. Where they are sometimes still used is where you've got a lease which has been excluded. And a case where that might happen is where a landlord at the start of a lease doesn't really know what their long-term plans are for some premises and might say that they're only prepared to grant, say, a 5-year excluded lease with a break clause after 2 years or something like that, because they're waiting for some planning to come through, and they need to have the right to be able to take over at an earliest.
So we've got a question on personal guarantees. So if you assign a lease to someone and they just disappear, what can you do about that?
Yeah, this is something I didn't mention.
Not often.
No, there are some safeguards there. I mean, someone in that position is in a terrible place. But one thing that is open to them, if it comes to that, is that they can make an application themselves to be put back in as the tenant. Probably not what they want, but it at least gives them control of the premises again. So, in the example that I gave that I've seen before is where they brought in a new tenant as an assignee, and then they vanished, and suddenly you as the previous tenant remain liable for a place you've got no control over anymore. You can put yourself into a position where you're back in control and running a shop you didn't want anymore. That might be better than just paying the rent for an empty unit, which otherwise you'd be stuck with. There are ways around this. As I said at the beginning, this is a greatest hits, really. There are a lot of deep cuts. Absolutely.
I think we've seen that in the questions, a lot of very specific things, and it depends on what people say in their contract. So just a final question from that was sent ahead. Forfeiture, is it the only way that a landlord can end an ongoing lease?
Yeah. It's the only way that they can do that where it's ongoing. There isn't any other option for them. No possession claim can be brought until all of the requirements for forfeiture have been dealt with, first of all, and that involves Section 146 notices or re-entry in the case of rent arrears. And it's a specific specialty being able to pursue these claims, and a lot of people might treat it the same as residential. It's not more difficult, it's not easier, it's just a different route that's less commonly seen down these parts.
And somebody's just put a follow-up here from the storm damage. So the lease says premises have to be put in the same condition and no general. Does that mean that there's no general wear and tear allowed? Would we need to put down a new flooring after being in the premises for just 10 months? So if the flooring has been damaged by the storms, where does the line get drawn between general wear and tear and a storm?
A lot going on there that I probably ought to look at in a bit more detail, but it sounds like there might actually be a clause that says that the tenant has to put things in good condition, and that could be quite difficult. You're looking at whether there's a schedule of condition at the beginning and what would constitute being equal condition, bearing in mind the age of the property and things like that, and what would be appropriate. It's probably beyond the scope of talking generally out loud here, but more than happy to talk to anyone afterwards.
Oh, we've got another couple of questions actually, if you're all right.
Yeah.
How do you know how much landlord redevelopment break clauses requested? I'm just reading this verbatim, by the way. Do you know how much the landlord redevelopment break clauses requested after the issue of proceedings and without a reply from the landlord to that effect, following a notice served? The case I found is B&M Retail versus HSBC and Ministry of Sound. What evidence of intention to redevelopment will be needed from the landlord, and when?
Intention to that was quite complex. Intention to redevelop, you need to be able to show. I think we're talking about the ground of opposition for an intention to redevelop, so that where a landlord is objecting to a tenant having new tenancy because that's what the landlord says they're going to do. It comes down to proving that it's a real intention that's able to be done. Broadly, I mean, you've got the authority there. I can talk in more detail to the person asking the question if they like, but all of these come down to, is this a genuine intention and is it something that can be practically pursued?
Okay, and last question on here. If a landlord sends a rent invoice that has not gone up in stages as stipulated in the lease, is that rent still owing?
Is this
need more detail probably on that, wouldn't we?
I think I understand the question to be related to rent reviews and rent increases, and I'm happy to be corrected on that by the person asking the question if they want to afterwards. What I'd say to that is that the requirements for rent review and rent increases to happen at particular points in the lease aren't so strict as break clauses, which are. So you're often able to backdate a rent review increase. It depends entirely on the terms of the lease, but that can catch some people out.
Okay, there's no more. So we've said a lot about, are you happy to kind of flash up your website or something like that so people know how to get in contact with you?
Yeah, I'll do a little closing and I'll show the website.
Perfect. Excellent. Yeah.
Okay, so that was a run through of things that I see most often when dealing with disputes about commercial leases. Not comprehensive, not intended to be, but hopefully you'll have picked up something from it that helps you. If you have a commercial lease, then there's a good chance that one or more of these things will come up at some point. And if you don't know where to turn, we can help. I'll be around for a bit now if anyone has any questions that they want to ask in private, as I say. We're Stut Associates. We're based in Cornwall at the Tremo Innovation Centre, and we deal with disputes exclusively. We're small but focused. We understand Cornwall's business community, and we won't charge out of county prices or leave you with someone unqualified or inexperienced. We're always happy to speak about concerns before they arise, or be ready to move if you think something might become a problem. Now, nobody wants to be friends with a dispute lawyer, so I won't ask to be besties, but our name and details might be useful to you when you least expect it and when you're in a hole. Let me get their website up. There you go. Please do think of us if you get into any bother with your lease. We might just be able to save you. And finally, thanks ever so much for listening and joining me on some things that are pretty difficult to make interesting and fun. And thanks.
That was really interesting. Thanks, Lee. That was really helpful. You're very active on LinkedIn as well, so you can follow Lee on LinkedIn. So yeah, we can. And thank you everyone for joining us today, and thank you for everyone who's watching the recording back. Thank you.
Thanks.